Thank you. Have a seat. We have 4 motions set this morning. Everybody's here, I assume. And if we hurry, we can get them all done. Thank you. All right, let's begin with the Mr. Baez, your motion to inspect the crime scene. First of all, is anybody here for the property owner? Looks like he was noticed. Why don't you go ahead with that? I don't know that you'll be opposed in that. Quickly.
Yes, sir. May it please the court. I had made several attempts to contact the property owner and was unsuccessful. I did receive a phone call from a woman who claimed to be the property owner's mother and was told that we would not have access to the scene. We have been advised by our forensic botanists that plant growth is now growing again. It's very important that we see the scene because there may be vital evidence to that area. So.
All right, State, did you want to be heard on that?
We've had no contact with the property owner.
And again, I guess it's maybe the Hendricks family or a Mr. Hendricks, is that right?
Correct.
All right, your motion's granted. You have access to the scene. Any and all access that you need. I suppose if they oppose this, we'll hear from them at some point, but you're certainly entitled to go there and inspect. Let's next do is Mr. Nejame here?
Good morning, Your Honor.
Good morning. Are you representing EquiSearch?
I am, Your Honor.
All right. Mr. Baez has filed an amended application for subpoena ducis tecum, and this is to get several items from EquiSearch, including, I guess, just records reports, photos, things like that, and you list them in paragraph 5, A through E. Why don't you briefly go through that? And Mr. Nejame has filed a request to strike your response, and I'll give you an opportunity to argue that in just a moment. Go ahead, sir.
Well, Judge, we think that any searches for a missing child are vital to the defense. Quite frankly, there may be witnesses among some of these volunteers who searched at or near that specific area. We don't know what was found. We don't know what was not found. And quite frankly, we'd like to be able to investigate where all of the areas that were searched, if in fact this area was searched. There's several inconsistencies made by either the volunteers or those people who are directly related to EquiSearch. And quite frankly, we'd like to
You know, I don't know that he's challenging the relevance of your motion. Now that I can see it. And I think what you request is certainly relevant to your case. I understand you're warning it. He's taken a different approach. You can speak to that. You're saying
Thank you, Your Honor.
the process needs to go through Texas and not here, basically, right?
That's one of the arguments, yes, sir.
Go ahead.
May it please the Court?
Yes, sir.
Presenting to the defense counsel a packet of cases, if I might approach the bench. Thank you, Your Honor. I've already provided copies to the State. We went ahead and filed yesterday, Your Honor, a response, and I believe it sets forth with specificity and in detail. May I take the podium, Your Honor?
Okay. Counsel, Mr. Baez, did you get a copy of his request yesterday?
I got a copy of it around 3 in the afternoon.
That's when I got it. I think that's when it was filed. Go ahead, sir.
Thank you, Your Honor. I'll first of all note that I've provided in descending order all of the relevant cases that are set forth in the memorandum. And they start from the first position and they descend downward from there. But basically, respectfully, there's a right and a wrong way of doing things, and this shotgun approach in the form of the motion filed by defense is nothing more than a generalized fishing expedition, which states with no level of specificity whatsoever the proper basis and the proper grounds, and it's not being done the right way. there is a way that this is done, and it's an application to the court, and there's a prong test, and the first is to establish materiality, and that this would be a material witness. The head of an organization, a nonprofit, doesn't even come close to suggesting that this is a material witness. And if in fact that somebody was to be deemed to be a material witness, there needs to be a subpoena attached. None of that was done. And then if in fact a subpoena was attached, it needs to go through His Honor, and then it needs to be sent to the appropriate court of jurisdiction in the sister state, that in this instance being Texas. So that, I think there's no issue whatsoever that there's simply no jurisdiction for His Honor, and I say that most respectfully, of course, but there's no authority or jurisdiction for His Honor to do that which has been improperly filed by the defense. Additionally, Your Honor, there are certain public policy grounds that need to be addressed. This is a very chilling effect. I'm looking for Mr. Conway. He's not here. We'll address that later. There's a very chilling effect as it relates to the public. Approximately 4,000 searchers came to assist in the finding of Kaylee Anthony. And all of those searchers would have presumptively believed that they were searching for the remains of Kaylee, sadly, because they were conducting ground searches. It baffles logic, and it's somewhat incredulous to suggest that those who are going out in order to find the remains of a child would in some way, shape, or form not report finding the remains of a child. So there's an internal inconsistency and illogic that just immediately slaps one in the face when they come across this. More significantly, there's been no showing or suggestion other than ambiguous, vague suggestions that there's been inconsistent statements about who found what and all that. Present a showing, put it down in a pleading, and do it the right way so that we've got some basis to springboard off of so His Honor can make an informed decision if we can even get past the jurisdictional issue.
All right, let me send it back to Mr. Baez. He says your request is flawed and there's a process that needs to be gone through. And I can just tell you, sitting here, I'm not sure that jurisdictionally I can help you as we sit here. Having said that, any response?
Well, two things, Judge. First off, it's always been our position, if you're